Welcome back to the deep dive. We're here again turning complex legal texts into, well, hopefully, knowledge you can actually use. Today, we're tackling a really critical part of patent law, what happens after a patent is granted, but uh-oh, there's a big mistake. We're diving into the MPP, the Manual of Patent Examining Procedures, specifically Chapter 1400 on correcting patents.
That's right. And we're narrowing our focus even further, right down to MPP Section 1402. That's the section titled Grounds for Filing a Reissue Application.
Okay, grounds for filing. So this tells you when you're allowed to go back and ask for a do-over, essentially?
Sort of a do-over, yeah, but a very specific kind. Think of Section 1402 as the bouncer at the door of the reissue club. It lays out the only reasons you get allowed back in to fix a major flaw in your granted patent.
So if you find a potentially fatal flaw in your patent, how do you know if it's fixable through this reissue process? What are we trying to nail down here today?
Our goal, really, is to map out that legal boundary. When does a serious mistake mean you can use reissue to save the patent, and when you're just stuck? And the absolute key phrase, the legal test we need to understand, is whether the original error renders the patent wholly or partly inoperative or invalid. That's the hurdle.
Wholly or partly inoperative or invalid. Okay, that sounds serious. Let's break that down. What kind of error actually meets that standard according to Section 1402?
It has to be a fundamental problem. The MPP is clear. You can file for reissue only if there was an error made during the original preparation or prosecution, back and forth with the patent office, and that error caused the patent to be inoperative or invalid.
And you mentioned a key distinction earlier.
Yes, crucially, the error must be substantive. It has to go to the heart of the patent's validity or function.
Substantive. So like if I just misspelled the inventor's name or missed a comma somewhere, that's not enough, right?
Absolutely not. That's exactly the point. Reissue isn't for cleaning up typos or minor clerical stuff, those kinds of mistakes. You typically handle them with the certificate of correction. Much simpler process.
Okay, so certificate of correction for the small stuff, reissue for the big, substantive, potentially patent-killing errors.
Precisely. Reissue is for when the error actually makes the patent legally vulnerable or unable to do what it's supposed to do, protect the invention properly.
Got it. So if we're talking about these major substantive errors, where do they usually show up? What are the most common reasons people need to file for reissue?
Well, they often fall into a couple of main buckets. First, errors in the claims themselves, the scope of what's protected. Second, significant inaccuracies in the specification, the written description or the disclosure part of the patent.
Okay, claims are usually the heart of it. When people think of fixing claims, they probably think of making them broader, right? To capture more territory. Is that the main use case?
That's definitely one use. Making claims broader if you accidentally claim too narrowly.
Yeah.
But, interestingly, you can also use reissue if your claims are too broad.
Too broad? How does that work?
Well, if your claims are so broad they cover stuff that was already known prior art, then those claims are invalid. Reissue lets you narrow them down to carve out that prior art and salvage the valid scope.
Okay, that makes sense. But you also mentioned correcting claims that are too narrow. That feels different. If you got a patent granted with narrow claims, isn't that just the protection you secured? Why is that an error?
Ah, that's where that phrase, partly inoperative, really kicks in. The idea is, if you could have validly claimed your invention more broadly based on your disclosure, but you failed to do so through error, then the patent isn't fully doing its job. It's partly inoperative because it's not protecting the full scope of what you actually invented and were entitled to claim.
Okay. Can you give an example? Because that still feels like a fine line.
Sure. A classic example is omitting narrower dependent claims. Let's say you only included broad independent claims in your patent. Later, you realize those broad claims might be vulnerable, maybe invalid over some prior art you found. If you had included narrower dependent claims during prosecution, those might have survived even if the broad ones failed. The omission of those potentially valuable, narrower claims can be seen as an error making the patent partly inoperative because you didn't secure the fallback protection you should have.
I see. So the error was failing to build in those safety nets, those narrower claims that were supported by your invention disclosure all along.
Exactly. And the courts have backed this up. You mentioned cases like in Tanaka and in Rewilder. They essentially recognize that failing to claim the full justifiable scope, including potentially narrower versions, can be a correctable error under the reissue statute.
Okay, that clarifies the claim scope issues. What about other foundational problems, like getting the inventors wrong or messing up the filing date priority?
Yes, those are definitely grounds too. Inventorship errors are a big one. Sometimes you can fix simple inventorship mistakes, with a certificate of correction under a different statute, 35 U.S.C. 256. But if it's more complicated, or if the certificate of correction route isn't appropriate for some reason, reissue is the way to properly add or remove inventors. There's an old case, Ex parte Scudder, that dealt with this.
And priority claims, missing those filing dates seems like it could be absolutely catastrophic.
It really can be. And yes, errors related to claiming priority, both foreign and domestic, are another key area where reissue can help, provided it was a genuine error during prosecution.
Let's take foreign priority first. How can a U.S. reissue fix a problem with claiming priority from, say, a German application?
Well, it's about meeting the U.S. requirements for claiming that foreign priority. The famous case here is Brenner v. State of Israel. In that situation, the applicant hadn't filed a required certified copy of the Israeli application with the USPTO during the prosecution of the U.S. case. That failure jeopardized their ability to rely on the earlier Israeli filing date. The court allowed reissue to correct that oversight, essentially, to submit the needed paperwork after the fact because its omission was deemed an error, rendering the patent potentially invalid or inoperative regarding its effective date.
Wow, so a U.S. procedure fixing a documentation issue related to a foreign filing. That's significant. What about domestic priority, like claiming the benefit of an earlier U.S. provisional application?
Same principle. If you failed, through error, to include the proper reference in your non-provisional application, to claim the benefit of an earlier provisional or even an earlier non-provisional under the rules, like 35 U.S.C. 120 reissue can often be used to insert that priority claim. It links the patent back to that crucial earlier filing date.
Okay, one more potential error source. The drawings. Can a mistake in the patent figures justify a whole reissue?
If it's a substantive error, yes. Meaning, if the drawing is wrong in a way that really misrepresents the invention or makes it impossible to understand how the claims relate to the structure. But there's a catch. Minor clarifications to drawings, things that don't rise to that substantive level, you can't file a reissue just to fix those. However, if you're already filing a reissue for another valid reason, like fixing the claims, you can usually correct minor drawing errors at the same time.
Right, they can tag along but can't be the sole reason. Okay, this leads us nicely to the other side of the coin. What can't be fixed? You said reissue is for errors, not regrets.
Exactly. This is maybe the most critical boundary to understand. Reissue is not a mulligan for strategic decisions you made during prosecution that just didn't pan out the way you hoped.
So the Patent Office draws a line between a genuine slip-up, an accident, and a calculated choice.
They do. The statute uses the word error, and the courts have interpreted that to mean unintentional mistakes, not deliberate strategic choices. You can't use reissue simply because you changed your mind, or because a strategy you chose turned out badly later on.
What's the classic example of an unfixable strategic decision?
The textbook example usually involves terminal disclaimers. Let's say, during prosecution, the examiner rejects your claims because they're too similar to claims. In another patent, you own a double patenting rejection. A common strategy is to file a terminal disclaimer. You basically agree that the second patent will expire no later than the first one. You trade away some patent term to overcome the rejection and get the patent granted.
Right, a tactical move to get the patent issued. So why can't you undo that later with reissue if you decide you want that term back?
Because filing that disclaimer wasn't an error in the sense the statute means. It was a conscious, deliberate choice made to secure the patent. You weighed the options and chose the disclaimer. The Federal Circuit case in Reed-Dinsmore made this crystal clear. The court said choosing to file a terminal disclaimer to overcome double patenting is a strategic decision, not a correctable error under the reissue statute, 35 U.S.C. 251. You made a bargain, and you have to live with it.
That really highlights the difference, doesn't it? Fixing a mistake versus second-guessing a strategy. The Patent Office is basically saying, we can help you fix accidents, but we can't help you fix buyer's remorse on your prosecution choices.
That's a good way to put it. Reissue corrects defects that genuinely impair the patent's legal standing or scope due to an oversight. It doesn't let you rewrite history on the strategic calls you made.
Okay, I think that brings us to a good wrap-up point for MPP Section 1402. Let's quickly recap. The main takeaway is that reissue is a powerful tool, but it's reserved for fixing substantive errors made during the patenting process that render the patent wholly or partly inoperative or invalid.
Right. Think things like claims being significantly too broad or too narrow, major disclosure inaccuracies, failing to properly claim priority, or significant inventorship errors.
And just as importantly, it's not for fixing simple typos. That's usually a certificate of correction. And critically, it's not for undoing deliberate strategic choices, like filing a terminal disclaimer, as underscored by the Inouye Dinsmore case.
Exactly. And before we completely sign off, our necessary disclaimer. This summary was put together using AI tools like ChatGPT and NotebookLM. It's for general educational info only, definitely not legal advice. For real guidance, you absolutely need to consult the official MPEP itself or talk to a registered patent attorney or agent.
Well said. And we also want to give a huge thank you to Mike Shepard, our creative director, who's been instrumental in putting this whole audio series together.
Yes, absolutely. Thanks, Mike. It's been great digging into these details.
So here's a final thought to leave you with. The law hinges on this idea of error versus a choice, or maybe just an oversight made during prosecution. But how clear is that line in practice? Think about failing to claim priority. Was it a genuine correctable slip-up? Or was it an oversight so significant it counts as a strategic failure you just have to live with? How do the USPTO and the courts really tell the difference? It suggests just how incredibly vital diligence and careful strategy are during that initial application process, doesn't it? Something to ponder until our next deep dive.